Hello, everyone, and welcome to our webinar on advertising and sponsorships as we come out of lockdown and adjust to the COVID environment. My name is Adam Rendell. I'm an advertising copywriter media specialist in our London office, and I'm happy to be joined by colleagues from London in Simon and Ziyang, Paris in Mark and Benjamin, and Hamburg in Dirk. For the next hour or so, we'll be discussing how regulators are reacting and what types of advertising are likely to be in focus at the moment. We'll be sharing our experiences in adjusting sponsorship agreements to deal with what happens when the sports or events that are being sponsored can't take place or can only take place in a very different way. And finally, we'll discuss some key principles for appointing media agencies to ensure the best possible outcome for advertisers. In one sense, it's strange that we should be talking about advertising at all. Economic outlooks are gloomy. Advertising at the moment and the world is focused on achieving racial equality. It's a priority like never before. And we're only at the beginning of the long journey back to normality. Ad spend in the UK has reduced dramatically. Out of home, print, TV, very cheap. And many sectors aren't advertising at all. But we are coming out of lockdown. France and Germany are way ahead of the UK in that regard. And Q3 and Q4 could be very interesting indeed. Already we're hearing that Q out of home and radio are very difficult to get hold of. Advertisers will be trying to convince their customers that they're ensuring social distancing, that they're looking out for the customers, and that there are good reasons to leave the house. If nothing else, the range and number of businesses attending this webinar give me at least some encouragement that people are thinking about their next campaigns and their next sponsorships. And when spend does start to recover, it seems to me there's going to be focus on ensuring that that investment is well targeted and that good practices are employed by media. Before we get into the substance, just one point of housekeeping. If you've got any questions as we go along, there's a Q&A button at the chat function at the bottom of your screens. Put them in there and we'll do our best to pick them up as we go along or at the end. Now, without further ado, I'm going to hand over the mic to Simon, who's going to talk about regulatory approaches and ad claims. Simon.
Thanks very much, Adam, and hi, everyone. Starting off with the UK, as a lot of the audience will know, advertising in the UK is regulated by a combination of legislation and self-regulatory codes of conduct. The ASA, the Advertising Standards Authority, is the self-regulatory body, and the statutory body is the CMA, the Competition and Markets Authority. So how have the CMA and the ASA responded to the current crisis? Well, since the start of the lockdown, both have published a series of guidelines, blogs, rulings, other explanatory notes, which have set out their various priorities and policies during this period. They've also both set up new reporting tools, which are there to help consumers make specific complaints about coronavirus-related ads and unfair commercial practices. So both taking the current outbreak very seriously and being quite proactive about it. The ASA in particular has announced changes to its regulatory approach during the pandemic. It said that it's going to apply a lightness of touch in some areas, but knowing when to prefer an advisory rather than an investigatory approach. But at the same time, it's also said that it will take a very strict stance on any advertisers who seek to exploit the circumstances for their own gain. And in terms of what we've seen in our recent interactions with the ASA, business is pretty much continuing as usual. They've been relatively relaxed in terms of deadlines that have been imposed. And there certainly hasn't been any reduction in the attention given to complaints that they receive and pass on to advertisers. If anything, what we've probably noticed more and more is that the ASA is going over their remit, being possibly overly keen to help and often contacting an advertiser before they've actually properly considered an issue or a complaint. So that's just something to be aware of. And interestingly, we found out that the ASA has recently furloughed some of its staff, probably a small proportion of its overall staff, but some relationship managers, for example, and that's quite surprising, given that we've been led to believe that they're extremely busy at the moment. So that's the general response in the UK from the regulators. I'll now pass over to Dirk, who's going to discuss the position in Germany.
Thank you, Simon, and hello, everyone. The situation in Germany is slightly different because we have a peculiar but pretty effective system of enforcing advertising standard rules and the rules of unfair competition that is probably different from what most of the rest of Europe has chosen to implement. So in Germany, there is no public regulator as such, but instead competitors and private consumer protection organizations have a standing to sue and to assert injunctive relief against the infringements of advertising standards and unfair competition rules. Now, that can be a very effective way of policing the market, because when you combine that with the fact that ex parte injunctions are pretty easily available in Germany and are enforceable immediately, very disruptive measures can be taken on short notice. So, for example, if a product does contain certain claims that are misleading, an injunction that can be rendered within days can prevent the company from continuing to sell it and may actually oblige it from to remove that product from the distribution chain. That system has been working well. How has it coped with the COVID situation? Well, it was certainly impeded to a certain extent by the fact that the operation of the courts has been at least made more difficult. Although the courts have adopted, for a time it was more difficult to get decisions quickly. But that's all back to normal now, and injunctions are rendered as they've been before the crisis. The public statements that were made by some of the leading competition associations, such as the Wettbewerbszentrale, pretty much focused on preventing the abuse of the current situation by advertisers who would make health-related claims or other claims that had a context with the COVID crisis, which were misleading and basically preyed on the fear of the public of the current pandemic. So that's the situation in Germany, and with that, I would hand over to my colleague from Paris.
Thank you, Dirk. Hello, everybody. So it's true that in France, we do have also the court mechanisms that were just mentioned by Dirk, but we do have also two main regulatory bodies that are relevant in the context of advertisement, which are the DGCCRF and the ARPP. The DGCCRF is that administrative body which represents the French states, more specifically the Ministry of Economy, and is as such able to pronounce fines and injunctive orders. But DGCRF is not only responsible to investigate misleading and illicit advertisement, but essentially all consumer and economic offense. We have also the ARPP, that is not an administrative body. It's a private self-regulatory body which has for purpose to regulate advertisement. The ARPP does not have binding administrative powers like the DGCRF, but can perform advertisement clearance for its members and also publish recommendations which are often used as a guidance by French authorities and French courts to assess an advertisement. So going back to today's topic, I'd say that the DGCRF did not specifically publish any guidance or approach on how they will tackle the advertisement during this crisis. They have been focused on other topics, I would say, such as price abuse and online scams that significantly increased during the lockdown. The ARPP, however, published some guidance through its blog and also a joint declaration with the International Council for Ad Self-Regulation and the European Advertising Standard Alliance, where they basically expose the main principles that should be respected by advertisers and are relevant during the crisis, but also during this end of crisis or future, which is basically to do a socially responsible advertisement, which does not take advantage of the current situation to exploit the fear of or the anxiety of person, or to oversell the characteristic of a product or a service. And more especially if this advertisement has a health-related claim involved. So it is mainly what we have as of today in terms of approach by regulator. It's not much, but I would say that the situation to some extent took everybody by surprise, including the regulators. And we think that we are now going to receive more guidance as well as example and court decision that will be relevant for the future campaign that will be directly or indirectly related to the future of this crisis. So now I will let Simon the speech to give more context on ad clearance and ad claim, which are for sure also relevant for France. So I will pass over to Simon.
Thanks, Benjamin. So what type of claims should advertisers be more careful about in the current climate? The first thing probably to note is that it's the circumstances rather than the actual rules on advertising which have changed as a result of COVID-19. And to a large extent, that's what the regulators have been reminding businesses, and it's more about existing key compliance points of the existing rules. So on the screen are 4 considerations that I'm going to briefly discuss, and these are issues that have arisen mainly in the UK and have been discussed and addressed in guidance mainly by the regulators. But obviously there will be other concerns as well. So if we look at these in a bit more detail, starting with promotions. So one of the many cultural impacts of COVID-19 is on the now cancelled Summer of Sport 2020. So we were going to have the Olympics, the football Euros, and other events that happen every year, tennis and Formula One, etc. Now this has had obviously a huge impact on sponsors and advertisers, many of whom may have already launched related promotions and competitions. So if you're a promoter affected by events which are unexpected and beyond your control, such as the current outbreak, you should refer, one of the things you should refer to is Section 8 of the CAP Code, which recognises that there are circumstances where promoters might need to rethink aspects of promotions. And if that is the case, then any changes to promotions must comply with the CAP Code. So some things to consider are being able to demonstrate why T's and C's have had to be changed. If the availability of promotional items is affected, promoters need to communicate this with consumers in a timely fashion and offer a refund or a reasonable substitute if that's possible. In terms of changing the closing date of the competition, generally that's not allowed, although there are obviously circumstances where that might have to happen, in which case it needs to be that such a change wouldn't be unfair to those who have already sought to participate in the original terms, or where that change in date would not disadvantage those people. So looking at subscriptions and free trials, now. Lockdown has obviously led to an increase in subscription services such as Netflix, Disney Plus, and other services such as food delivery services. But even with that increased demand, it's still important for advertisers to make it clear to consumers exactly what they're entering into. So the ASA is particularly hot on making sure that people know exactly what they are signing up to. Free trials must be genuinely free, and any auto renewals must be clear. So it's very important that significant conditions must be included up front and not hidden away. For example, typical ones that we'll see are whether the subscription will continue automatically after the trial, how to cancel the subscription, and the extent of the commitment if the subscription is not cancelled at the end of the trial period. So those are significant conditions that must be upfront and clear to the consumers. In terms of pricing, the CMA has been monitoring pricing, and this is an area it's particularly active in the UK. The obvious point here to make is that businesses shouldn't charge inflated prices in the current climate, and they must consider the context of any price rises, but also at the same time consider any price reductions and discounts. So, for example, where a reference pricing has been used for a period and the discount is maintained as a COVID promotion, be careful, because that lower price may then take over the reference price if it's been used for too long. So that might end up making it difficult to run price discounts in the future. Essentially, the longer you extend your promotions now, the harder they might be to bring back. So that's something to be aware of. In terms of health products, very simply, think twice before you make any claims which state or imply that they could help prevent, treat, or cure the virus. If you are going to make such claims, just ensure that they're supported by robust documentary evidence before they're actually published. Can you mention the pandemic in ads? Well, there's nothing to say that you can't, but it's important that it's not done in an exploitative or inaccurate way. We've all seen that supermarkets in the UK have been quick to produce ads which reference the new safety rules for shopping, but they've also been careful not to imply any need to stockpile certain items. But outside that, there has been some media criticism of certain businesses inappropriately corona washing, so essentially seeking to ally themselves with the national effort and frontline workers, but without any actual particular connection to them. So this is just something to bear in mind. I'll now pass over to Dirk. Dirk, are these sort of similar to the issues that you're seeing in Germany?
Yes, they very much are. In preparation for this webinar, I went through the case reports and looked for a few cases that may already have been decided, and I found two things. I found mushrooms and masks. And with that, we can turn to the mushrooms. This is a website that is reproduced from the case report, published by an institute. It calls it Institute for Nutrition and Mushroom Healing. It's not a great translation, but that's what it says on the website. And the claim here was corona infections, how we can protect ourselves with vital mushrooms. Now, and here it says healing with mushrooms at the top. Now, that was taken to court, and not very surprisingly, the court found that this violated the German pharmaceutics advertising law because it made a misleading claim to a therapeutic effect that the product does not actually possess. So the most remarkable thing about the decision probably is that the court felt compelled to state that it found in favor of the plaintiff because there was no randomized placebo-controlled double-blind study to support the claim that this mushroom pulver could somehow prevent a corona infection. So an obvious case, but it was still necessary to take these people to court to get it removed. A second thing that has moved the public and industry in Germany in relation to advertisements referring to the pandemic were face masks. As you all know, there was a great scarcity of personal protective equipment. There still is. At the same time, people were asked to wear masks in certain environments, such as when they went shopping or were in other close or more confined spaces where the social distancing requirements couldn't be fulfilled. So quite a few people, from private citizens selling on Etsy or eBay to clothing and apparel companies, started producing these cloth masks, which of course did not comply with the requirements of the Medical Devices Directive, which usually needs to be the case for medical masks. So that meant that those masks did not have a CE sign, weren't subject to a conformity assessment under the directive, and therefore couldn't be sold as medical or protective equipment. And indeed, we've advised quite a few clients on how to advertise for those products, because it was really a balancing act to sell these items as items of clothing rather than personal protective equipment, while at the same time making sure that they are sold in response to the requirement to wear those masks when out in public. With these two examples from Germany, I would pass on the baton to the next speaker.
Thanks, Dirk. That's me again. So I'm just not going to spend too much time on this slide, but I think that the main point to take here is that it's really important for advertisers to consider ads in the context of current events and how they might be perceived. And that's one of the key points that has come out of recent rulings and guidance that we've seen in the UK. And I think that probably applies across Europe as well. In particular, consider the 4 principles on the screen. I'm not going to run through them, but it's important to take note of them. In terms of influencers, we've received mixed signals from the influencer industry since the start of the crisis. Some seem to have benefited from the outbreak, whereas others have really suffered because of the reduction in ad spend and the reduced ability to create content in lockdown. There's been some commentary in the media that this could be a watershed moment for the industry, for the influencer industry, and it could break the current bubble. But we're not so convinced, and I think we're pretty likely to continue to see a rise in the use of influencers in the short to medium term. So there are obvious benefits to using influencers even now, such as their ability to adapt quickly to changes in circumstances and obviously to engage directly with their captive audience. But if you are using influencers, it's important to make sure that they abide by the usual rules. So obviously we all know about the use of hashtag ad, but also make sure that they're aware of any additional COVID-19 considerations. What we found in the last year is that influencers, particularly celebs, they're taking a more careful approach to disclosures, and that seems to be the general way things are moving forward, possibly because of the fairly recent CMA investigation. But a common error that we are seeing is that even when they have used ad, they're not disclosing this prominently enough. So it's often hidden at the bottom of a tweet or at the bottom of an Instagram post, and that's possibly not compliant with the rules. So that's just something to bear in mind. And just the final point on influencers is just to remember that the same rules apply to affiliates. So affiliate marketers are essentially treated as secondary advertisers. So you just need to make sure that their content complies with the rules as well by making it clear that it's advertising. So I'll just pass over to Dirk now, who's going to discuss direct marketing to consumers.
Yes. Well, one of the responses that companies have chosen in face of severe restrictions of getting their usual advertising to eyeballs was to engage consumers more directly through the use of their own apps, through the use of chat platforms like WhatsApp and others. This is a strategy that has been rolled out very successfully by certain sports apparel companies in China, and it has worked well in Europe and the US as well. Of course, it does run into major regulatory issues. As we all know, direct marketing is subject to very strict rules, and as a company, you do need to make sure that you have all requisite consents and all requisite agreements with the consumer, which allow you to reach out to the consumer and engage him. But if that is dealt with, if those hurdles are taken, it can be a very powerful tool to engage with the right people and to drive online sales through those apps and platforms in the face of closed retail locations and other hurdles posed by the pandemic.
Great, thanks, Dirk. So the final point in the slide is just remember to consider existing campaigns as well as new campaigns. That brings us into the following two examples. So you may have seen this in the media recently. KFC paused its Finger Licking Good campaign following concerns that it conflicted with global advice by health organizations to do with hand washing. Probably not a huge surprise, but the ASA did receive over 100 complaints about this campaign before it was withdrawn. Similarly, in the US, Coors Light announced that it was stopping an upcoming campaign which advertised its beer as the official beer of working remotely. Amid fears, it would look like it was taking advantage of people working from home. So again, these two examples are all about context and remembering the context in which ads appear. And on that note, I'm going to pass over to Zhu Yang.
Thanks, Simon. Hi, everyone. As Simon's already alluded to, a particular form of advertising that we've been looking at a lot during this time has been events and sports sponsorship. So while right now we're all very excited about the return of the football, obviously for much of the last few months across all of our jurisdictions, live events and sport haven't been happening. So we've been looking at sponsorships both in the context of what happens under existing agreements and how do we account for what's happening with COVID in new agreements or in amendments. One of the first questions we're asked by clients with existing agreements is, from the brand's perspective, do we still need to pay even though we're not receiving rights? And from an event organizer or a club's perspective, are we liable for not providing the rights? So collectively, we'll start by looking very briefly at the legal position, and then we'll move on to what's probably the more interesting question here, which is how parties to sponsorship agreements have actually chosen to navigate this period and the learnings that we can all take away for future agreements. Looking first at the legal position then, the instinctive reaction to the event cancellations that have been going on might be to think about force majeure and frustration. And I don't propose to get into the details of those concepts here, at least from an English law perspective, as they've been very well covered in other sources, and we'll be happy to point you to our Taylor Wessing resources on this, but others on the panel will touch on the French and German equivalents in a moment. Before they do, though, I would just flag that actually, because of the way that sponsorship agreements tend to be set up, the answer to these questions may well already lie in the other express terms of the agreement. So often there'll be a clause allowing the event organizer or the club to substitute rights if there are some other rights that can't be provided. And we've also seen agreements where the obligation to provide sponsorship rights at all is expressed to be subject to all applicable laws, or a similar industry concept like football regulations or similar, meaning essentially any rules made by the football governing bodies. And where that's the case and rights can't be provided because events or matches can't be held under the relevant rules, then that creates a situation where, depending on how the payment terms are set up, the brand might still have to pay, but the event organizer or the club isn't in breach for failing to provide rights. So that's worth bearing in mind. And I'll pass on to Benjamin now for the French perspective.
Thank you, Xu Yang. So I will not also have the time here to give extensive details on the French legal framework, but as a global picture, it's true that currently force majeure and what we call hardship or imprevision, which is the French equivalent for frustration, are indeed currently the most and still debated legal principle in the context of this crisis. The main issue we are currently facing for force majeure today is to understand when COVID is a force majeure event and when it is not. Because basically saying that COVID is force majeure is not true from a pure legal standpoint, because it will depend on what is the contractual obligation that is impacted. If you take the example of sponsorship agreement, it is true that for a club that cannot display the trademark of the sponsor because the event was cancelled is probably a force majeure event, but because in this situation there is nothing much the club can really do to overcome the fact that the event was cancelled. But if you take by opposition the payment obligation of the sponsor, COVID does not prevent you to pay. So it creates a very complicated legal debate currently on how force majeure impact the performance of French agreements that unfortunately I will not have the time to get into too much details, but I would like to expose briefly another concept we have at the French law, which is hardship. So it's actually a quite recent legal concept because it was introduced in French law only in 2016. So hardship is essentially the right for any contractual party to renegotiate its agreement if an unforeseen event at the time of signature arise and makes the performance excessively onerous for such party. So this legal right requires party to renegotiate, and if the renegotiation fails, the parties can decide mutually to terminate the agreement, or if they don't agree on the termination, they can also refer to the courts that will decide the legal consequence, including financial, of this termination. So in the context of sponsorship agreement, and depending on course of the terms of the concerned agreement, there have been indeed such negotiation process. We have seen this type of negotiation, and some of them did fail. So now it will be interesting to see if parties will bring to courts this renegotiation and for the courts to decide the outcome of the termination of the agreement based on this concept. So I will now pass over the speak to Dirk that will expose the German equivalent of force majeure and frustration.
I think Dirk's having telephone difficulties, maybe we carry on.
So sure. I think Dirk has a difficulty. So Xu Yang, would you want to lead?
Sure. So I guess moving on then to the more forward-looking elements of this. In our experience as a group, and I think this is true across our jurisdictions, we've generally seen parties to sponsorship agreements wanting to find a practical way forward, whether that's an existing agreement or an agreement that's currently under negotiation. A lot of these agreements are long-term arrangements, and the parties want to be able to weather these tougher times and keep the partnership going in the future. So generally, we've seen parties finding a negotiated solution, and that could take a number of different forms. And these solutions could also be used for new sponsorship agreements going forward. So the first option is to provide for substitute rights. For example, your summer 2020 event might be substituted with a winter 2021 event. And we've also seen extensions of the term of the sponsorship. So the brand would still pay as normal, but they would receive rights for an extra period of time to account for the period where events aren't happening because of COVID. There's also the possibility of a pro rata fee reduction or refund for the rights that aren't delivered. And this might be a standalone solution, or it might be used in conjunction with a term extension after a sort of long stop date. Bear in mind with this, though, that the amount of the refund can be quite tricky to provide for. So it might not simply be a case of, well, you thought you'd get 20 events and 10 of those haven't happened, so you get 50% of the fee back, because there might be other rights. For example, rights to feature on websites or social posts that are still being delivered and still have value. Ideally, if it's possible to ascribe values to the relevant rights at the outset, then that makes the calculation of a refund easier. But that not always being practical, it might be necessary to fall back on some kind of expert determination in case the amount of any reduction or refund can't be agreed. And lastly, I would just note that whatever solution is being considered, whether or not it'll work might depend in part on whether the sponsorship element of a partnership is just one piece of a wider puzzle or not. So where products and services are being provided, or there's some other sort of commercial arrangement in addition to the sponsorship, then it'll be important for the parties to find a solution that works for the deal as a whole. So Dirk and Benjamin, I'd be interested to hear if these are also the sorts of solutions that you've been seeing in your jurisdictions.
Well, yes, we have seen in France a lot of clients negotiating the condition of suspension, performance of their agreement during the crisis. And we have seen a lot of them accepting actually to suspend performance or payments, not because they have a legal right to do so, but just because they want to be good economical partners. So yes, we have seen indeed mutual acceptance of suspension and extension of agreements. We have also seen adjustment of pricing structure, going from, for example, from a fixed price structure to a variable price structure. We have seen even out-of-the-box solution where, for example, the commitments were taken by parties to organize virtual events in case physical events were to be cancelled in the future. And this is clearly something, personally, I think we should all take into consideration when drafting our agreement in the future. The legal principle I explained previously on force majeure and hardship can be adjusted. They can even be excluded in B2B contracts under French law. So I think it is very important for us lawyers to know directly address this creative solution in force majeure, suspensions, or termination clause, because we have all seen, I think, that neither the law or the standard boilerplate provision that we can sometimes include in this type of clause may be not sufficient to efficiently address the consequences of a crisis like we faced. So I think it's indeed a learning we can have from this crisis is to address this solution in this type of clause in the future. So and now I will pass the talk to Dirk, that I think is back and that can present his view on the German aspect of this question.
Yes, thank you, Benjamin. I'm sorry for cutting out. So first, I'd like to second the observation that Benjamin just made about practical and reasonable solutions that have been found in most cases. One example from Germany is that Sky has been very supportive of the Bundesliga during the term where the games could not be televised, and that of course will probably pay out long term because it does help to strengthen the relationship between these partners if the support does continue through times of hardship, as it apparently did here. Another observation that we have made is that different drafting strategies in sponsorship agreements can have a huge impact on the practical implications of the COVID situation on a contractual relationship. So the perception is that contracts based on common law drafting traditions often, not always, but often tend to have quite detailed provisions on reduction rights and ongoing performance obligations in the case of a lot of eventualities. And of course, these are mostly meant to reflect a change in the value of an endorsement, but they will often be applicable to the current situation. So for example, a sponsorship deal may have a formula to reduce compensation for a team or an athlete commensurate with the number of missed appearances in a certain competition or league. And if something like that is in the agreement, applying such contingency provisions can be fairly straightforward and an easy solution to the questions at hand. Now, in the continental tradition, we do sometimes see these provisions as well, but more often there are more general rights to adjust compensation in line with certain unforeseen events. And on the upside, this can create more flexible solutions, but it does, of course, also create considerable uncertainties and may lead to more disputes. These kinds of contractual structures are often chosen because they allow for a quicker signing of the agreements, because the parties don't have to agree on how to deal with all kinds of eventualities that may never occur. But as the last months have told us, it may indeed be prudent to spend more time thinking about events that people would not usually expect to happen. A key element of the sponsorship agreements and how they deal with the current situation is certainly the remuneration structure. Looking forward, I think the only thing that we know for certain is that we will have to deal with a lot more uncertainty, as nobody knows how the pandemic will play out and how long businesses will have to contend with the economic consequences of the current situation. But remuneration agreements within the sponsorship deals can reflect this fact. Instead of a high base salary, it can be preferable to adopt more flexible remuneration models. And the details will, of course, always depend on the specific sponsorship or endorsement agreement and the nature of the endorsement that is granted. But it can, for example, be sensible to move to a more royalty-based model, or to tie the compensation to certain metrics for the exposure that the sponsor wishes to receive through the sponsorship. Of course, there will often be pushback against such remuneration models from the entities who are selling their rights. People do love reliable revenue streams, but in the current situation, such arrangement will possibly enable sponsors to enter into an arrangement that they would otherwise have shied away from under the current circumstances. One word to the section that I missed above, the force majeure. We do not have a concept of force majeure as such under German law. We will find force majeure clauses in many agreements, but it's not a statutory concept as such. What we do have is a provision that is possibly similar to the French concept of hardship, which is basically meant to address a fundamental change in the circumstances on which the parties jointly base their agreement. And if there's an unforeseen change to these circumstances, a party can have the right to have the terms of the agreement adjusted if it cannot be expected to reasonably stand by the initial agreement anymore. Now, it's obvious that this is not something that is applied very often because it really does require exceptional circumstances, but these may well exist in the current environment. But even then, it's not entirely helpful because Obviously, the parties will generally have very different ideas of how the contract should be adopted to adjust to the changed circumstances, and it can be a very lengthy and possibly litigious process to establish the new and more appropriate obligations under the agreement with that concept. And with that, I think I'll hand back to Chuyang.
Thanks very much, Dirk. I completely agree with what you've both said about it being incumbent on us now to try and anticipate and provide as much as possible for the uncertainty that we can't really avoid at the moment. And along that vein, the next point on the slide is drafting for COVID-19, and by that we mean how can you effectively draft provisions in your sponsorship agreements that expressly deal with the situation that we're currently facing. And the first point I'd mention here is be careful not to inadvertently limit the application of any special COVID provisions only to COVID-19 or only to the current wave of the epidemic that we're seeing now. Where we're in a situation where a second wave or a new strain could well emerge. And if, say, next year there's a new strain and it's COVID-21, then technically that's not COVID-19 anymore, but presumably you still intend for the special COVID provisions to apply in the same way. And the second point here is think more broadly about when the situation should be treated as being affected by COVID and when the situation should be treated as being back to normal. So we might have a scenario where events and sports are technically allowed to take place, but artists don't want to perform, or people don't want to attend events with large crowds, or there are social distancing measures. And all of these things could affect exposure and consequently the value of the sponsorship rights. So you might want to think not only about whether events venues are technically open to the public, but about the level of bookings or footfall or the quality of the acts, and possibly to compare that to 2019, for example. In the sports context, games may be taking place but behind closed doors. And if that's the case, is the exposure through games being televised as good? Well, maybe yes, if games are actually being more widely televised and more people are watching. But then again, maybe not, depending on what your sponsorship rights are. So as an overall message, it's important when providing for COVID to think about all of the possible scenarios and what the consequences might be in the round. And that takes us on to whether there might actually be new or different opportunities arising during this time. And I'll pass back to Dirk.
Yes, thank you. I mean, as you said, sports and other events have suffered massively, and they're now played under entirely different circumstances. And the impact on the value of endorsements is obvious. I mean, fans who cannot go to the grounds to watch their teams may certainly be less likely to purchase the new season's jersey, and matches are played in empty stadiums, and much of the local advertising in the grounds has become worthless. But in response, there is an interesting development in that other forms of advertising become more relevant, in particular virtual advertising. And there are reports that La Liga, the Spanish league, is considering having tweets by fans virtually projected on the stands. And other forms of virtual advertising are also conceivable, such as virtual fans on the stands dressed in the sponsor's merchandise. And this can certainly create additional and sorely needed revenue streams, but it does raise contractual and regulatory issues. So the current sponsor, main team sponsor or sponsor of the ground, may well argue that this should be part of the rights that he has acquired for the venue. And that could lead to conflicts between different sponsors who all claim those rights. And if he has those rights, is there an obligation to pay additionally for it? There are regulatory concerns in that, for example, in Germany, virtual advertising must principally be imposed on advertising that would be visible in the grounds locally. So something like projecting it on the stands will be problematic. But people are thinking about this very intensively, and we have developments, for example, with the German league, where the viewer has the option to have virtual chants from a crowd that isn't actually there played into the video signal just to create more atmosphere. And there's a cooperation between a video game producer and the Spanish league to add new camera angles to the game. And all of these virtual elements, of course, create an opportunity to add other content and possibly advertising content to those streams as well. It's very early stages, but I think it's certainly something to keep an eye out for and something that can be an exciting opportunity for advertisers.
Sure, sounds like there are some very potentially interesting developments there to keep an eye on. And that wraps up the sponsorships part of this webinar, and I'll hand over to Adam on media buying now.
Thanks, Ziyang. On to the final topic now for the webinar, as Ziyang said, media buying. Now, as spend reduces, there's going to be more focus on ensuring it's spent correctly and the value derived from it is properly captured by the advertiser. Out of that focus, it seems to me, may come reviews on how media agencies operate under the contracts under which they're appointed. This could produce an opportunity for more progressive partnerships of agencies, more advanced service agreements. We've been doing that in the last few years anyway. But it seems to me it's an opportunity for that to increase. And if that happens, we would advocate focusing on 5 key principles, which I've put on this slide. That's going to achieve improved transparency, income pass-through, and better behaviors. Firstly, transparency. That's at the core of a trustworthy and high-achieving agency relationship. It's got to be embedded throughout the agreement. And that's going to include things like reporting all income and having a wide definition of income, wider than the traditional AVB approach. We'll talk about that more later. Fundamental to achieving proper transparency is that the obligations have got to apply across the group. If the agency contributes to the services, touches the spend, receives value from the spend, it should be included in the transparency obligations. There've got to be reporting obligations covering actual prices, opportunities to benefit from income. Where's the income coming from? What individual items of income have been received? Ad tech platforms have been under a lot of scrutiny. Advertisers need to know who they are, how they're paid, what the engagement terms are, what income is being earned by the agency by using such platforms. There should ideally be a prohibition on use of proprietary or inventory media without specific approval and reporting being in place. Mere presence in a media plan, I don't think is going to be good enough. And making sure there's a broad definition of what proprietary media actually is. And some agencies will try to exclude certain types of media acquisition from their transparency obligations, particularly non-client transactions. So I'd encourage caution to be exercised there. Those transparency obligations have to be backed up, though, by robust and comprehensive audit rights. That audit access has to be across the agency group and service providers. Enabling that, it's ideal to have a contracting party higher up the corporate structure than the individual trading company, so that parent company can provide guarantees of access across the group. As with transparency obligations, that audit right needs to encompass every agency which has touched the spend or provided services. The auditor needs access to a whole heap of documents, trading records, third-party cost information, the entire chain of contracts, documents about income, full chain of pricing for programmatic media. We're actually seeing that media owners, particularly digital media owners, are recognizing the importance advertisers are placing on transparency and audit and are requiring disclosure of those deals to the agency's clients. Advertisers have got to be alert to exclusions from access, restrictions on the choices of auditor. You don't want audits being sort of carved up between different people doing different things because that risks things falling into the gap. Thirdly, income has to be passed through. It's going to be transparently and comprehensively reported and then passed back in a form appropriate to the income that's been received. That way, the fee is the only source of revenue that the agency can retain. There needs a broad definition of income, that picks up any value as it comes into the agency group in relation to media payments. It's got to be beyond just rebates and free space. It's got to go into things like technology, affiliate, reselling, and product margins. If profit is received by a trading company or any other entity in the agency group, widely defined, as I've mentioned, it's got to be passed through. Agencies should try to avoid income being earned aside from the fee. So advertisers should try to avoid income being earned aside from the fee. For example, agency margins being charged on digital tools. And finally, on income, the advertiser may need to decide if discounted or free space is to be retained as returned as income or would be delivered in pricing commitments. Underpinning all of this is the fourth point, which is legal standards which underpin those behaviours. Robust standards, for example, that although the agency is going to be acting legally as principal at law, at least in the UK, it's not entitled to act on its own behalf. Most importantly, we try and seek to impose fiduciary and good faith duties on agencies. And there should also be obligations to maximise value for money and demonstrate how media placements have achieved that best available value for money. And finally, the fifth point, just to pick up on that point about value for money, advertisers need to know their spend is going to be achieving the best result possible, and the agency behaviours are geared around achieving that. Those decisions of behaviour by what is best for the client and not for the agents. Advertisers should seek assurances their media plans are not influenced by undisclosed margins, benefits, or income, or other arrangements made with media owners. It's media neutrality. Agencies must avoid conflicts of interest. Those might include not being able to set media plans on that media neutral basis, recommending placements or media owners for reasons other than the best interest of the advertiser, or provision or receipt of services provided at a premium. Agencies should be required to demonstrate whether suppliers they've selected are objectively the best placed supplier. That requires, for example, disclosure of use by the agency of linked, related, or group companies in delivering the services. So as you'll appreciate, the 5 key principles that I've just been outlining there, to my mind, I think can be distilled into 3 words: transparency, income, and behaviours. Those 3 words should run through the agreement like the words for a stick of Blackpool rock, for anyone who's had the pleasure of eating that. Well, I hope that's been a useful summary of what we've been seeing in media agency appointments in recent years and empowers advertisers to obtain better outcomes. Now, we've also been seeing advertisers appointing agencies across multiple jurisdictions. So we build framework agreements under which local amendment agreements operate to adjust circumstances for particular markets. In the US, for example, agencies actually act as agents rather than principals, so you've got to adjust for that. And another one is the impact of the Sapin Law in France, and Mark in Paris is going to outline how advertisers can use that to their advantage.
Thank you, Adam. Hi, all. It's true that when talking about reassessing expectation, advertisers targeting French audience may indeed take advantage from the transparency principles resulting from a specific piece of legislation usually referred to as the Sapin Act. This act regulates ad inventory transaction, and its objective is to prevent intermediaries to purchase media inventory and then to resell it with a margin without media on one side and the advertiser on the other having visibility on pricing conditions set by the intermediary. The Act provides for 4 key principles. The first one is that the intermediary buying inventory to the benefit of an advertiser must do so under a written agency agreement. This means that the intermediary can only act in the name and on behalf of the advertiser, and this excludes any resale with a margin of the inventory. The agent is further under a strict disclosure obligation as to any capital links with potential media vendors. As a result of this agency relationship with the advertiser, the agent can only be paid by the advertiser by the way of a commission, and the agent cannot receive any fee or benefit from the media vendor. So we have here very strict transparency obligation on the side of the buying agent, but the Act also provides for some obligation on the side of the media vendors. First obligation, the invoice from the media vendor has to be addressed to the advertiser, even if payment is made by the agent. And any discount granted by a media vendor as part of the transaction must be stated on said invoice. Second obligation, the media vendor shall report directly to the advertiser on the condition under which the services were provided. In this respect, the Act has been recently amended to cover new digital advertising tools or methods, more specifically real-time bidding transaction. Specific reporting procedure by media vendors to advertisers are now set so as to enable advertisers to be communicated a set of information regarding performance of the service, including by the way of KPIs. Enforcement of the Act is organized by the way of criminal sanctions that may apply both to legal representative of the corporation involved, but also the corporation itself. And one should remember that in relation to corporation violation of the Act, it can go up to €1,500,000, depending on the violation. So one can see that the Act provides mainly obligation towards the buying intermediary, but also sets some obligation towards the media vendor. It aims at ensuring transparency at all steps of the inventory supply chain, and it gives efficient tools to the advertiser to control both performance and pricing of their ad campaign. I will pass it back to you, Ed, for our conclusion. Adam?
Thanks, Mark. It's interesting there to hear that the French legislature seems to be kind of instilling the behaviours that contractually I was talking about into law. So that's some quite could be quite powerful tools there for advertisers in France to use. Well, that brings us to the end of today's session, and I've put here. You've seen us all apart from Dirk on the video, and this is what we used to look like before lockdown began. We will all look forward to meeting up in person as soon as we can, as lockdown is released. And I think we go forward into the night knowing that mushrooms don't cure COVID-19, at least not in Germany. So on that bombshell, I wish you all a good evening and wish you all the best of health, and we look forward to catching up with you all very soon. Goodbye.